Now again, I have the honor of introducing the next three panelists. I'll introduce Doug first, and then have about 30-35 minutes each, and then we'll go through the panelists that way. Doug White was chief of the Tsilhqot'in. Not even close, eh? See? Really? Sanaimo. Sanaimo. Okay, there we go. First Nation in Nanaimo, BC, from 2009 to 2014. His Coast Salish name is Keewatin. Keewatin. That's why you asked me to do this introduction, right? And his Nuu-chah-nulth name is Tsilhqot'in. Jeez. Okay. I'm going to make you say Opascua at Cree Nation when we're done this. Hopefully I'll mess that up. He has been a director of the Indigenous Bar Association of Canada and an associate lawyer at Mandel Pinder. As chief, a major focus of his work was implementation of the Tsilhqot'in Treaty of 1854. From 2010 to 2013, he was a member of the First Nations Summit Task Group and the BC First Nations Leadership Council, working on the Crown's duty to consult and accommodate and advocating with governments and the United Nations. He is the director of the Center for Pre-Confederation Treaties and Reconciliation at Vancouver Island University and an associate at First Peoples Law. Douglas.
Asiam Nasiaya, Entapek Keewatin Tani Stanemo, Entapek Clishan Tani Hupachasit, Aitna Shkwalavan, Konas I Haitsebka, Treaty 1 Mastimo, Haitsebka Siam Mastimo. Good afternoon, everyone. My name is Doug White. I want to give recognition and respect to the Treaty 1 nations on whose territory we're gathered up to discuss these important issues today. I want to really thank very much Dr. Harry Bone for his opening prayer and remarks at the outset of this day. And thank to our hosts, Amy Kraft of Robson Hall, James Wilson of the Treaty Commission of Manitoba, who did a fine job introducing me. Thank you. And the Center for Human Rights Research. That's another dimension of hosting this important discussion and dialogue. There's a number of things I want to talk about that I intended to talk about, but I'm shifting my talk a little bit based on what we've heard today. And I want to talk about a little bit more, emphasize the broader trajectory of how the legal process has played a role in the broader issues that are unfolding in society about what is the single most important public policy issue in this country, and that is the Crown First Nations relationship. The issue of First Nations and their relationship to themselves and to each other and to their territories. The decision this summer, in particular the Tsilhqot'in decision, was an answer to well over 100 years of advocacy. Going back to a time in British Columbia, in the early 1860s, late 1850s, a policy of denial took root in the colony of British Columbia and Vancouver Island. That decision to uphold and to move away from a treaty-making process on Vancouver Island from 1850 to 54, to shift away from that recognition and respect into an approach of denial and administration, is the fundamental decision that has configured so much of the legal and political issues in British Columbia over that period of time. What this is about at its root, what this issue is all about, is about the simple dignity of Indigenous peoples to be Indigenous, to be who they are. An important aspect of being Indigenous is being part of an Indigenous family and community and nation of people. that has a very specific and particular relationship with a certain part of the world, a certain part or space of the planet's surface. These things are inherent in their definition and their mutuality of each other. There cannot be Indigenous peoples without an Indigenous territory. That Indigenous peoples gather an important part of their identity and who they are from their relationship with their territory, from the stories and mythologies that are told that are at the root of who they are in the cosmos, in terms of their cosmology, about how they came to be who they are in this certain part of the world. Maintaining and seeking to achieve and to restore that aspect of Indigenous people's dignity is the common cause of First Nations across the country. It's what's at the root and the core of so many different examples over the last century and a half of advocacy, of people standing up. The first moment of advocacy I'm aware of with my own people in relation to the Crown relationship post the treaty being established wasn't very long after the treaty was established. It was less than 10 years later that Stanemo chiefs were having to stand up to advocate and request that the Crown show respect and recognition to the treaty relationship that had just been established. That in our conception, recognize the Aboriginal title of our peoples to our village sites and the resources that we depend upon. A fundamental premise of the treaty relationship being recognition and respect for a way of life and for an opportunity to find a sharing of space, a sharing that doesn't require interference or a knocking down or a dispossession or a displacement of Indigenous peoples and their territories and their way of life. Over the course of the early part of in the early part of the 20th century, the first major Aboriginal political organization that was across British Columbia was formed to advocate for this very issue that the court finally answered this summer. The Allied Indian Tribes of British Columbia, the great leaders Andy Paul from the Squamish First Nation and Peter Kelly from the Haida First Nation, advocating over the course of a decade or two, their work culminating in that retrograde decision in the Indian Act in 1927 to prohibit this kind of a discussion. First Nations to gather up legal representation to advocate and talk about their relationship to their territories. There was a firm commitment to the idea that was expressed earlier today that somehow these issues don't matter and they can be put aside and pushed and suppressed, and that Canada is something different and doesn't include recognition of those issues. So firm and powerful was this new mythology and official storyline of the Crown in British Columbia that the original treaties had to be suppressed and denied as well. There's very few treaties in British Columbia. I come from a nation that has a treaty, the last treaty negotiated in the Pre-Confederation era, December 23rd, 1854. By 110 years later, when Clifford White and David Bobb were out hunting in the summer of 1963, when they stood in front of court, the magistrate the next day, and talked about that treaty relationship, when they stood up in the most dignified way on a foundation of their knowledge about who they are, the dignity of having that knowledge, of the oral history of their relationship with the Crown, they were faced with utter and complete ignorance from the court system of the day. Neither the magistrate nor the prosecutor had any clue what these people were talking about. It was utterly and completely inconsistent with the official narratives of the province. Everybody knows there's no treaties in British Columbia. What are you talking about? What an astonishing, powerful storyline that was. We know that the Stanemo people gathered up a Supreme Court of Canada decision that had that treaty recognized. In what became the first statement of the modern era of Canadian Aboriginal law, the treaties of Vancouver Island were recognized to be treaties. They were recognized and stated to be of continuing relevance and that they would be legally enforced. And that what they meant in the context of the issue at trial was that the provincial government could not have the Game Act apply in a way that would interfere with the operation of the treaty rights of the Stanemo people. That's the bedrock of 50 years of Canadian jurisprudence that continues to unfold today. That basic statement resonates and finds repetition and echoes throughout half a century of Douglas Treaty jurisprudence and treaty jurisprudence in this country. It's important to keep in mind when we're thinking about the broad trajectory of where we're at and the role that Canadian Aboriginal law is playing, that we've got a deep depth of Canadian jurisprudence about treaty rights. We've got now a full statement about what Aboriginal title means. We've got a full statement in decisions like the Ahousaht Nation decision about what Aboriginal rights are and can be. I don't think there could be a more expansive statement about Aboriginal rights than the Ahousaht Nation decision. What's missing in all of that, it's important to keep in mind at this particular time, is the issue of self-determination and self-government powers of Indigenous peoples. And as others have talked about already today, in particular Ovid Marcredy, the content and the substance of self-government and self-determination has somehow been sidetracked. It's been waylaid through the politics of the last generation. That there was a real intent and intention to seek to have these issues resolved in the constitutional conferences after 1982 that failed, and then later in the major constitutional discussions in Charlottetown Accord that also failed. In the jurisprudence itself, it's also important to think about, in terms of the Tsilhqot'in decision, we must pay careful attention to the nature of what Aboriginal title is and the way the courts have described it. Because herein lies, notwithstanding the fact that the courts have avoided self-government and self-determination for the most part over the past 50 years, inherent in the description of Aboriginal title is a governmental power that will have to find its voice and its space to breathe in. I'm sure that many of you here in the room share the experience I had when I was reading the Tsilhqot'in decision at probably from 6:45 to about 7 a.m. on June 26, Western time, Pacific time, when that decision came out. And my shock at the capacity of the Supreme Court of Canada to unanimously be able to state conceptions of these major issues of Aboriginal title, federal power, provincial power, and to be almost completely silent on the issue explicitly of self-government of Indigenous peoples. As Professor McNeil spoke earlier, this is a key point. When we think about what the courts have done, I want to tell a really quick story about the development of Aboriginal title law in the courts. The Calder decision arose in 69 through to 73. It shifted fundamentally the white paper and the development of the first iteration of the comprehensive claims policy when Trudeau recognized his error, talking about treaty rights and Aboriginal rights as historical might-have-beens. I was wrong, he said. We need to resolve these issues. They mean something today. They must find a space within Canadian Confederation and constitutional law to continue to be relevant and to live and breathe. Later in Delgamuukw, of course, it's important to keep in mind that the court refused for technical reasons to make a legal declaration or to make a decision. This opened up a pattern which really put the question squarely in front of all of us. The basic question of, is Aboriginal title justiciable or not in the Canadian legal process? because we saw in Delgamuukw and we saw in Tsilhqot'in itself this consistent and repeated judicial acrobatics to find technical reasons not to make a decision. And we know that part of the context for that was because of the creation of the BC treaty process in British Columbia in the early 90s. That somehow judges were saying, we don't see this as our proper role. We're happy to talk about the doctrine of title, the theory of title, but in terms of actually resolving these issues, please go and sort this stuff out, go and sit down together and talk. And we saw that in the Tsilhqot'in Treaty Group expressed what was a shared frustration of First Nations across the country when they brought a petition to the Inter-American Commission of Human Rights, a request of that commission to say something about their inability and incapacity in Canada to establish and reestablish their Aboriginal title. We know that Canada aggressively defended and sought to have the petition struck down for lack of proper standing. We don't know what these people are doing here down in Washington, D.C., but they have not exhausted their domestic remedies. They could have easily gone to the courts to ask for their title, or they could have gone to the BC treaty process to have their title established. The Tsilhqot'in Treaty Group nations themselves, in addition to numerous, dozens of First Nations and organizations across the country, put forward briefs to the Inter-American Commission to talk about the history in Canada leading up to that time period. In an extremely embarrassing decision of the Inter-American Commission for Canada, they confirmed and agreed with the arguments of the Indigenous peoples. They said, the Canadian legal process provides no answer to Indigenous peoples. After decades of litigation, tens of millions of dollars spent, there is not one single grain of sand in the second largest country on the face of the earth that has ever been declared to be Aboriginal title. The BC treaty process, for its part, quite the opposite of being a process of establishing Aboriginal title, in fact requires First Nations to set aside their title interests, to effectively extinguish them. This all amounts, both the litigation strategy taken by the Crown, I recall, and it's important to share the statement of Tom Berger, who was the appeal lawyer in White and Bob for my nation, the Snuneymuxw, in the 1960s, and then who, Frank Calder was an important supporter of Snuneymuxw when he was an MLA at the time. Those two remarkable gentlemen brought forward the Calder arguments to the Supreme Court of Canada, and they argued the case over the course of a week, something about a week of time. And at the 30th anniversary of the Calder decision, Tom Berger talked about, this was about 2 weeks after the closing of the Tsilhqot'in litigation, the 339 days. He said it's important for everybody to reflect upon why did it only take the Calder litigants a week of time to argue Calder, but it's just taken 5 years of time and 339 days of court time for the Tsilhqot'in. And he said there's a very simple answer in this. And that answer is in the way that the Crown seeks to take the legal process as an opportunity to engage in a war of attrition with First Nations peoples, to seek to grind them out through a miserable series of defenses and arguments, lawyers' nonsense, to seek to make the legal process out of the reach of First Nations. A very specific strategy. In Calder, he said, the Crown did what they should have done, what they should always do. What's the honorable thing to do? To admit the basic facts of the issue and to get on with the real substantive conflict. Leave that to, if the court can provide help in a process, then that's a good thing. But when, as in the Ahousa decision, the Crown takes a position that they're going to start, in terms of their defense, they're going to start with a denial of the very existence of an Indigenous people, to say to my relations on the west coast of Vancouver Island, the Nuu-chah-nulth, our first line of argument and defense to the claims of the Nuu-chah-nulth people to an Aboriginal right or an Aboriginal title to the west coast of Vancouver Island is that there never was a Nuu-chah-nulth people. You go and prove that. We deny that there ever was a Nuu-chah-nulth people. That's a complete and total disgrace. It's a dishonor to the profession. It's a dishonor to the legal process. That kind of behavior needs to come to an end. And I think what we see in the Tsilhqot'in decision of the Supreme Court of Canada is an expression of judicial frustration and loss of patience with the ineffective political processes that were not responding to decades of judges saying, please go and do your work. Effectively, the failures that I've described boxed the Supreme Court in, where they had to make a decision, finally one way or the other. Is Aboriginal title justiciable? Will the legal process be a part of Canadian law in relation to resolving these critical issues in Canada? I want to finish by talking about the importance of Indigenous governance and the Indigenous legal orders and traditions that Professor McNeil and others have referred to today. That inside, when we think about what Aboriginal title is, the way that it's been described, it's important to recognize that Aboriginal title has one legal foundation in property law, private property law, and another more important legal foundation in the law that guides the relations of states or nations to public property. And that when looked at in whole, this is really a public property type interest and relationship that's being described in Aboriginal title. Ownership is a component of that, but there's definitely jurisdiction at play. And so we need to find, this is important because for some reason it continues to be obscure to both Canadian citizens, federal government, provincial governments, this idea and this capacity for Indigenous peoples to articulate their own systems of law. We should never be in a situation in 2014 when a court can say things like, my gosh, provincial law must apply. If it didn't, there would be a legal vacuum. And I remember when reading that morning of June 26th, thinking, how did we ever end up in a place this time and age when a Supreme Court can unanimously say such things, be so bereft of any acknowledgement or recognition of the need for Aboriginal peoples to have their own self-determination and self-government in relation to themselves and their territories. We see that the consent principle is now a fundamental part of Canadian constitutional law. That it's because of the structure of Aboriginal title being collectively held, that it's territorial in scope, that it's inalienable in part because of obligations to future generations, but also because of an incapacity on private citizens to engage in what is really a governmental type of property relationship. Private citizens can't operate on the plane of sovereigns and of states and of peoples. That's an important part of what the inalienability of Aboriginal title is about and what it describes. When the exception to inalienability, the only purpose for that exception that's stated that it can be alienated to the Crown is to fulfill the imperial project of the Crown to achieve their plenum dominium, which is now fundamentally inconsistent with the reconciliation imperative that's developed over the last generation. My view is there can never be another such kind of extinguishment. We've got to think about the implications of that, both for what consent requires. When you look at the dimensions of Aboriginal title and the way that it's structured, this obligation to future generations, this analogy to the equitable doctrine of waste, that it's really, it's stating in different ways trying to find a way of describing a sovereign's relationship to territory and what limits that kind of an actor's relationship to the property that they have a trust in relation to. In research I was doing this summer, it became clear that in the early development of the doctrine of Aboriginal title in Canada, there was probably some reference to the public trust doctrine in the United States. And trying to pretend I was a detective of some kind, I actually drew a connection between Justice Corey's, one of his clerks, published a paper on the public trust doctrine at the same time Delgamuukw was being sorted out. The public trust doctrine obviously doesn't have much of a home in Canada. It's an American doctrine. But I do think that there's aspects of that doctrine that we need to think about and look at to see how it informs our understanding of what Aboriginal title is, so we can better grapple with and understand the consent framework that's in front of us now. What is consent all about? What is the fiduciary relationship both that the Aboriginal government or title holder has to the Aboriginal title? And how does that constrain, how does something like the public trust doctrine constrain both the Aboriginal government but also the federal or provincial government, should they seek to somehow infringe upon the Aboriginal titles of Indigenous peoples? In some important ways, I would put forward the idea that the Tsilhqot'in decision overturned Haida Nation and shifted away from this weak, impoverished, process-focused duty to consult, and made clear that we now need to shift into substantive relationships that reflect consent and decision-making power of Indigenous peoples in relation to their territories. I would caution people advising government and industry to seek to maintain the status quo. I can see clearly that that approach will only lead to deep conflict and uncertainty on the ground. That if the idea is that we merely need to consult, that's not enough. We have to the Crown must turn its mind to the simple reality that what's required is a focus upon a consent relationship premised on recognition and respect. The idea that we will simply shift to consultation and justification of infringement is a pathway of deep uncertainty and conflict. And I think about now the gap that exists in relation to Aboriginal title and the ideas that were expressed in Keewatin. And I want to share with you the project and the work as I see it that's now in front of us to overcome some of the implications of the Keewatin decision. And I want to reflect and share that in my time as a leader of my people, I arrived in a position at Snuneymuxw that, notwithstanding the fact that we had a Supreme Court of Canada decision that recognized our treaty, notwithstanding the fact that we have the highest statement that can be politically uttered in Canadian society in Section 35 of the Constitution Act, that somehow when I arrived half a century later, 2 generations later as the Chief of Snuneymuxw, the Crown was operating in a way that fundamentally and completely denied the treaty relationship. I was shocked and felt naive. And I had to sit with my counsel to work to understand the limitations of the legal process, that it's necessary, but it's not sufficient by itself. That what we require to bring our nations and to bring the country to a place of proper recognition and respect and dignity is a comprehensive strategy of treaty implementation that takes into account the need for legal process and what it can offer, but also that it's obviously not sufficient by itself. I mean, I could rattle off a list of a dozen Supreme Court of Canada cases that have been completely ignored by both the federal and provincial governments. Clearly, the legal process is not enough by itself. Politically speaking, it's an absolutely critical dimension of the work, but also not sufficient. We have Section 35. We had the constitutional conferences. We've got the treaty process. We need to think about other dimensions of the relationship and implementation in terms of economics, and most importantly, social change. We've got to find a way to help Canadians understand these issues. Holy man, sitting here this morning, these are complex issues. I remember when I was in law school thinking about Section 88 and thinking, I think this is the most complicated stuff that I've studied so far. And I have to admit, I still don't quite understand what Professor McNeil said this morning about Section 88. I'm going to have to talk to him at dinner or something and try and understand it a little bit more. The complexity is mostly about lawyers arguing about lawyers' things. These issues are really at the core simple, straightforward. It's about what we were talking about, what some of the leaders here with us today were talking about. We're seeking something simple in terms of re-establishing our relationship with our territories and seeking a space to stand on our own. We need to encourage Canadians to understand what that project's all about and about how it's not a threat to Canadian society. In the way that Justice Groberman in the BC Court of Appeal decision talked about, I think we can only go with Aboriginal titles so far as it doesn't interfere with Canadian sovereignty. That diminished conception about who we can be as a country needs to be displaced with a strong, clear model and pathway that reflects a reconciliation that we can achieve if we work together. And so I encourage, in terms of this seemingly large gap that exists between Tsilhqot'in, what was said there, and what's been said in Keewatin, that at the end of the day, I think that the decisions are simply, at least on the treaty side, are simply going to deepen the need for Section 35 to do the original work that it was intended to do. That we're going to have hard work to push and define the scopes and the limitations of the Crown's capacity to infringe. That was created out of the air in the Sparrow litigation. This analogy to Section 1 that's not anywhere in the Constitution, but that was created for the purpose, the idea that the Crown must have some capacity to infringe. And since Sparrow, the main emphasis of the legal process has been about equipping the Crown with powers to infringe. When I look at the Keewatin decision, I wonder, my gosh, are we back in the 19th century? Is this the St. Catharines Milling decision? Where in God's name is the Aboriginal voice in all of this? We can't have that. That's not a proper way for the court to play a role in resolving these critical issues. The criticality of these issues to the Grassy Narrows peoples, when you read the decision, I think Heather spoke earlier, or maybe it was someone else that spoke earlier about, we're talking about trying to put in place laws for fire safety and for things where the provinces might not have scope under the division of powers and under IJI, and then all of a sudden, and the treaty relationship between the Crown and First Nations. There is no proportionality there to the thought. We need to shift and we need to return. I agree with what Ovid said, because I believe that what Tsilhqot'in does is it prompts a return to the constitutional level discussions, to sit down and do the work that hasn't been done. That's what the court says in Tsilhqot'in when they make that expansive decision and when they make clear this is a justiciable issue and we will make decisions. And we reject a century of impoverished litigation strategy of the Crown and arguments of the Crown. And we want to make clear that Indigenous peoples have territorial scope interests in their territories. And you better get on with the work, the real work in front of you to resolve these issues. So I'll leave it at that and leave time for more questions and discussion. I want to say again, thank you to everyone, and thank you to everyone in the audience that has put forward comments and raised questions. This has been an extremely beneficial opportunity for me to hear from all of these different voices. Thank you.